India Legal presents Courts Roundup.
Hello, I am Tanya Chugh and you are watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. Before we begin, here are the headlines. Hearing a plea against farmers' protest, Supreme Court recommends formation of Committee of Farm Bodies and government representatives to resolve the issue. Impledes farm bodies, issues notice. Supreme Court issues notice to Centre on separate petitions seeking uniform grounds of divorce and maintenance for citizens across the country. Bombay High Court makes observation on contempt hearings, says judiciary must not waste time on contempt hearings, should hear important questions of law instead. Centre tells Kerala High Court no provision for allowing entry of transgender persons to armed forces and NCC. It is prerogative of Centre to decide entry.
India Legal presents Courts Roundup.
While hearing a plea against farmers' protest and the consequent road blockage, the Supreme Court said that the farmers' protest in and around Delhi could soon snowball into a nation issue, and the top court is, therefore, mooting formation of a committee to hold talks and settle the matter amicably. The petitioners have sought immediate removal of protesting farmers from border areas of Delhi NCR on the ground that they increase the risk of COVID-19 spread in Delhi.
The Supreme Court has indicated that a committee including members of farmer organization may be formed to resolve the deadlock and end the farmers' protest. The observation was made by a bench headed by CJI S.A. Bobde while hearing a batch of PILs seeking removal of farmers protesting at Delhi borders against the three Farmers Acts. The court observed that the negotiations being held by the government are not yielding results, and if the dispute is not settled soon, it may become a national issue. The court has granted permission to implead all concerned farmer organizations and has issued notice on the PILs returnable tomorrow or Thursday. The CJI informed the Solicitor General that tentatively a committee will be formed with members of all farmers' organizations from the rest of India. Otherwise, the top court apprehended this will soon become a national issue and the government may not be able to work out. During the course of hearing, the Solicitor General assured the court that the government will not do anything against the interest of farmers. He urged that a direction be made to the farmers' organization to sit with the government clause by clause so that there can be a discussion or debate with an open mind. At this juncture, the CJI remarked that the negotiations being done by the government are not working. He suggested that talks will be successful only when both the sides are represented by such people who are actually willing to negotiate. The CJI therefore asked the Solicitor General to come up with the name of such an organization that is willing to negotiate. He also said to make sure that the authorities are willing to negotiate. The petitioners have sought immediate removal of protesting farmers from border areas of Delhi NCR on the ground that they are increasing their risk of COVID-19 spread in Delhi. Advocate Reepak Kansal for the petitioners submitted that there should be a balance. There is no free movement. Ambulance cannot go. This is a violation of Article 19(1)(a), (b) and (c), he submitted. The CJI then remarked that the petition seems ill-conceived and there are no legal issues before the court. He said, the only party before us who has blocked the road is government. The Supreme Court has issued notice on a batch of petitions which challenge the constitutional validity of the Farmers Acts. Bureau Report.
The Supreme Court has issued notice to centre on separate petitions seeking uniform grounds of divorce and maintenance for citizens across the country. Two separate PILs filed by BJP leader Ashwini Kumar Upadhyay stated that women across all religions ought to be treated equally, and if some religious practices deny them their fundamental rights, such practices should not be protected.
A three-judge bench of the Supreme Court comprising of CJI Justice Bobre, Justice A.S. Bopanna and Justice V. Rama Subramaniam issued notice on two public interest litigation seeking uniformity in the personal laws regulating divorce, maintenance and alimony for Indian citizens. Senior advocate Pinky Anand, appearing for the petitioner Ashwini Kumar Upadhyay, prayed that these personal laws and religious practices are discriminatory under Article 14, 15 and 44 of the Indian Constitution, as well as other rights conferred under international instruments. The plea seeks direction on the Ministry of Home Affairs, Ministry of Law and Justice and Ministry of Women and Child Development. CJI Bobre, however, was unconvinced over the arguments advanced by Pinky Anand. CJI said, "You are asking us to encroach upon personal laws and remove the distinction that they create." Anand put reliance on the Shaya Bano case, where the Supreme Court had recently declared the practice of triple talaq as being unconstitutional. Anand argued that the prayer was to remove discriminatory practices, co-religion and other religious practices infringing the fundamental rights of Indian citizens. Meenakshi Arora, representing another petitioner, argued that the case comprises of a larger issue. She said, "Religious practices are one thing, but constitutional rights are another. When religious practices directly infringe the fundamental rights, they cannot be said to be protected." The petitioner has sought directions from the court. It has asked the Union Home and Law Ministry to take appropriate steps to remove the prevailing anomalies in the ground of maintenance and alimony in order to make them uniform for all citizens without discrimination on the basis of religion, caste, sex, or place of birth in spirit of Article 14, 15, 21 and 44 and international conventions. Bureau Report.
The Supreme Court has upheld the Competition Commission of India order which dismissed the complaints of cartelization and anti-competitive practices by cab regulators Ola and Uber. A three-judge bench of Justices R.F. Nariman, K.M. Joseph and Krishna Murari also set aside the National Company Law Appellate Tribunal, finding that the informant in the case, Sameer Agarwal, had no locus standi to move to the Commission.
The Supreme Court has upheld the order of the Competition Commission of India and NCLAT, wherein it had found that Ola and Uber do not facilitate cartelization or anti-competitive practices between drivers who are independent individuals who act independently of each other. A three-judge bench of Justices Rohinton Fali Nariman, K.M. Joseph and Krishna Murari set aside the preliminary objections raised by the respondents against the appellant filing information before the CCI and filing an appeal before the NCLAT. The appeal was filed at the instance of an informant who describes himself as an independent practitioner of the law. The appellant sought that the Competition Commission of India initiate an inquiry under Section 26(2) of Competition Act 2002 into the alleged anti-competitive conduct of ANI Technologies Private Limited, that is Ola, and Uber India System Private Limited, Uber BV and Uber Technologies, together referred to as Uber. It has been alleged that they entered into price-fixing agreement in contravention of Section 3(1) read with Section 3(3)(a) of the Act, and engaged in resale price maintenance in contravention of Section 3(1) read with Section 3(4)(e) of the Act. Informant submitted that the Ola and Uber apps function akin to a trade association, facilitating the operation of a cartel. Further, since Ola and Uber have greater bargaining power than riders in the determination of price, they are able to implement price discrimination, whereby riders are charged on the basis of their willingness to pay, and as a result, artificially inflated fares are paid. The appellant, informant aggrieved by the order of the CCI, had filed an appeal before the NCLAT, which had upheld the order of the CCI and also delved into the locus standi of the appellant and dismissed his appeal. Bureau Report.
A dispute over a Kerala-based hospital's mistake in releasing a dead body to the wrong family, thereby depriving the deceased man's family the opportunity to see him a last time and conduct his final rites, has reached the Supreme Court. The family moved the Supreme Court after the compensation payable to them on account of hospital's error was cut down by the National Consumer Disputes Redressal Commission. A Supreme Court bench comprising of Justices R.F. Nariman and Naveen Sinha on Monday stayed the National Commission's order, while issuing notice. In 2009, the children of one Purushottanam were shocked to find that his dead body had already been released by the Ernakulam Medical Center to another family and that he had been cremated before the hospital realized their error. Their order has now been challenged by Purushottanam's family on various grounds, including the following. While the National Commission passed the operative portion of this order in July 2019, it took over 7 months to issue the Commission's reasoned judgment in March 2020. The order was passed by a bench comprising of only 2 technical members, while the complex questions of law in the dispute warranted the inclusion of judicial member on the bench. No reasons have been provided for assigning a sum of Rs 25 lakhs to the State Consumer Forum's legal aid account. The award of only Rs 5 lakhs compensation is unjust and inequitable. The National Commission's order suffers from a non-application of mind. The Delhi High Court has issued notice in a contempt plea for non-compliance of orders passed in a public interest litigation concerning seismic stability of buildings in the national capital. The contempt action is sought against Chief Secretary of Delhi Government, Commissioner of Municipal Corporations and Vice Chairman of Delhi Development Authority. The contempt plea was heard by Division Bench of Chief Justice D.N. Patel and Justice Prateek Jalan. It is the petitioner, Advocate Arpit Bhargav's case that in spite of several orders and opportunities, the authorities have failed to chalk out and implement a detailed action plan for surviving an earthquake. The petitioner also claims that requirements of Seismic Zone 4 are also being followed by the authorities, which is contrary to an order passed by the court in 2016. It is submitted that in its previous orders, the court has time and again expressed its anguish over non-compliance of its order and even observed that there was a disaster waiting to happen. The petitioner further points out that in spite of various orders, the central government is yet to file a counter affidavit. The last National Lok Adalat of the year was organized on Saturday through virtual and physical mode across the country under the aegis of the National Legal Services Authority. During the day-long event held under guidance of Executive Chairman of NALSA, Justice N.V. Ramanna, COVID-19 guidelines were strictly adhered to by state legal services authorities and district legal services authorities. For conducting National Lok Adalat, a total number of 8,152 benches were constituted by 31 SLSAs, which managed to dispose of 10,42,816 cases. Out of the total cases disposed of, 5,60,310 cases were at the pre-litigation stage, while 4,82,506 cases were pending in the courts. According to NALSA's portal, the settlement amount of these cases was nearly Rs 3,227.99 crore. During the National Lok Adalat, the cases pertaining to labour dispute, money recovery, MACT cases, land acquisition, maintenance cases, NI Act cases under Section 138, criminal compoundable offences, matrimonial disputes except divorce, service matters relating to pay, allowances and retirement benefits and other cases were taken up. The Supreme Court Collegium has recommended the elevation of Dr. S. Muralidhar as Chief Justice of Odisha High Court and Justice Hima Kohli as Chief Justice of Telangana High Court. Dr. Justice S. Muralidhar has been recommended for appointment as Chief Justice of Odisha High Court. Justice Muralidhar, whose parent High Court is Delhi and transferred to Punjab and Haryana High Court in February 2020, where is currently functioning as a puissant judge. The decision was taken at a meeting of the Collegium held on December 14. While hearing an argument regarding freedom of speech and expression, Bombay High Court has made an important observation. Justice S.S. Shinde said that judiciary must not waste precious time in contempt hearings, must be open to criticism.
Bombay High Court has made an important observation regarding contempt hearings. Justice S.S. Shinde of Bombay High Court has said that judiciary must not waste precious time on contempt hearings, which can otherwise be utilized for hearing important questions of law. He added that court and judges must be open to criticism from public. Contempt of court powers, he added, should be used only as a last resort and weapon and should not be used against a layperson criticizing court or judges. The remarks were made in the context of argument advanced by Dr. Avinav Chandrachud of Freedom of Speech and Expression. The bench, which also comprised Justice M.S. Karnik, was hearing a plea by Sunayana Hole, accused of passing objectionable comment against Maharashtra Chief Minister Uddhav Thackeray and Cabinet Minister Aditya Thackeray. Dr. Chandrachud, representing Hole, was arguing on the importance of freedom of speech to express opinion against government official. When the bench opined that the individual occupying position of power must learn to tolerate criticism. Extending the same yardstick to the judiciary, Justice Shinde said that the court should also learn to take critical opinions and statements against it. He pointed out how the parliament has exclusive power to impeach a judge should they want to take an action against the judges. However, if someone from the society make a comment criticizing a judge, then such criticism should be allowed, he added. Chandrachud said the people against whom action is taken get more attention than they would get otherwise. He gave an example of action being initiated against a comedian for a statement which would have otherwise gone unnoticed. A valid reference is to stand-up comedian Kunal Karma, against whom contempt of court is pending before Supreme Court. Chandrachud also submitted that there was an element of malafide in the action of Mumbai police since they were targeting Hole, who had certain ideologies and beliefs. The court, however, pointed out that even in mature democracies, the freedom of speech was not absolute. Bureau Report.
Vikas Khanchandani, CEO of Republic TV, has been granted bail by the Chief Metropolitan Magistrate at Esplanade, Mumbai, in the TRP scam case presently being probed by the Mumbai police. Khanchandani was granted regular bail by the magistrate following his arrest last Sunday by the Mumbai police. Following his arrest, he had been remanded to judicial custody for 2 weeks. During remand proceedings, the police had submitted before the Esplanade court that Republic Network, in order to increase their television rating points, allegedly carried out transactions amounting to ₹15 lakhs a month in order to ensure that more viewers watch their channels, Republic TV and Republic Bharat. After interrogating Ghanshyam Singh, Assistant Vice President of ARG Outlier, the police concluded that Singh was allegedly being directed to carry out illegal activities to increase TRPs for their channel by Chief Operating Officer of the channel, Priya Mukherjee, who in turn was being instructed by Khanchandani. Defense lawyers contended that Khanchandani was being targeted because he is working for the Republic TV network. It was also pointed out that Khanchandani was deliberately arrested on Sunday, a day before his anticipatory bail application was listed for hearing before the Mumbai Sessions Court, so as to defeat his anticipatory bail application. In a blow to efforts of transgender persons seeking parity in opportunity for entry to armed forces, the central government told the Kerala High Court that there is no provision in law allowing entry of transgender persons to armed forces and national cadet corps, and it is the prerogative of the central government to decide whether or not the same should be allowed.
while stating that it is prerogative of central government to constitute a new division for the third gender. The central government has submitted before the Kerala High Court that as of now, only male and female genders are allowed entry to National Cadet Corps, NCC and armed forces, and there is no provision in law allowing entry of transgender persons to the same. In an affidavit filed before the High Court, the Centre and NCC said that as of now, there is no provision for enrolling only boy and girl cadets in NCC. Besides, since the aim of NCC is to groom cadets for future with the armed forces, and the armed forces do not have provision for entry of transgender person, the same is absent in NCC as well. Any induction of a candidate who is not from male or female gender without due deliberations by the authorities will have far-reaching ramifications, the affidavit added. The affidavit was filed in a petition by a trans woman, Hina Hanifa, who moved the Kerala High Court challenging Section 6 of the National Cadet Corps NCC Act, which allow only males and females to enroll the corps. Sex reassignment surgery from male to female, and has now been issued with the transgender identity card by Social Justice Department of Government of Kerala. In the petition, it was emphasized that the inclusion of sexual minorities such as transgender person is necessary to address the rampant marginalization and discrimination faced by them. This affidavit challenges Section 6 of the National Cadet Corps Act 1948 as illegal and ultra-vires of Article 14, 15 and 21 of the Constitution to the extent that it excludes the transgender community from enrollment with the National Cadet Corps. Importantly, it had also been stated in the affidavit that there is no provision existing for entry of transgender in the Indian Armed Forces. It is important to note that in National Legal Service Authority versus Union of India, the Apex Court had declared transgenders as the third gender and had affirmed that the fundamental right granted under the Constitution will be equally applicable to them, and gave them the right to self-identification of their gender as male, female or third gender. Bureau Report.
That's all for Courts Roundup. Keep watching APN.
India Legal presents Courts Roundup.